So there we go, the official recording in process. I am going to do a quick welcome and introduction to myself and to the session and what the layout of the session is going to be. And then we're going to run over just quickly some ground rules. Then I'm going to go as quickly as possible over to our 4 speakers today, because let's be honest, that's who we're all here to hear from, really. And of course yourselves. So firstly, thanks all for coming. As I said at the start, if anybody needs closed captions, you should be able to enable them. I am also going to try to speak slowly and clearly so the closed captions can pick up on my accent. I would ask everyone else to please try to do the same. So you're all very welcome joining us today for our 4th of our everyday rights conversations. This one is on rights resourcing, and we have 4 fantastic speakers. So what's going to happen is we are going to have about 5 to 10 minutes presentation, kind of introductory remarks from each of our 4 speakers. And then we're going to go into the meat of the session, which is to take you through the 4 key discussion points in turn that you were sent with the joining instructions. So that's what it's going to look like today. And sorry, I should introduce myself. My name is Helen Flynn, and I'm Head of Campaigns, Policy and Research at Just Fair. Just Fair itself is a UK-wide charity, and we focus on what we call the rights of everyday life. So those are your economic, social and cultural rights. It's things like health, like housing, like education. We are absolutely delighted to have you here today, but just for all events that Just Fair runs, we like to lay out some ground rules just so that everybody understands what to expect and the behaviour we expect from ourselves and from others. So I will run through them very quickly, and you'll already receive these in your join instructions email. So firstly, the idea of our ground rules is that we take a human rights-based approach. We try to break down barriers that may be presented to people to take part. So that's why these exist. It's about taking a human rights-based approach. Firstly is safety and well-being take priority. As I said in the joining email, for example, there may be some content when we talk about people's real lived experiences that people, for a variety of reasons, may find very upsetting. Please do take care of yourself. If that happens, feel free to leave the session, for example, and come back in, whatever you need to do to look after yourself. Secondly, we respect and we value difference. And that's not a passive thing. We think difference brings great value to our work and brings great richness and diversity. So we do really look for those differences of opinions and those differences of experience. All opinions count. That's very much related to my prior point, because we know that knowledge and expertise comes in many forms. Some of us have gained our knowledge and expertise from the things we've read. Some of us have gained it from the things we've experienced. And for many of us, it's a mixture of the two. We believe that all these kinds of knowledge and experience and expertise are hugely valuable and really help strengthen our work. This is a safe space for learning. I often say that human rights is a journey, and none of us is perfect. We're all on that journey. So let's try to be respectful of each other, but understand when perhaps we don't get everything right all the time. At Just Fair, we commit ourselves to actively listening to what people are telling us and to improving and doing better. We hope that you can all also do the same in this session. One way we do that is by asking people to fill in a short feedback form, which my wonderful colleague Laura will share in the chat shortly. And that's just a 2-minute feedback form just to let us know how this went and where we can improve, because we do want to keep doing better and keep learning and growing. We ask you to be respectful. That's things like assume good intent, don't interrupt, although I know that is much harder when you're in an online sphere and you can't read the physical cues as easily. And also respond to what's in front of you, not what you imagine someone may be saying, thinking, or meaning. Finally, share the air. Again, this is more towards the discussion space afterwards, but do take responsibility. Each of us have personal responsibility as well as my facilitator responsibility to ensure everyone has time in the conversation. And that includes being really conscious of who has and who hasn't contributed. So just to say very quickly, these sessions are being run as part of the UK Economic, Social and Cultural Rights Network. If you're interested in getting involved in the work of that network, then I'm going to ask my colleague Laura to also share a link to the network in the chat. The next session is going to take place on the 4th of June. And again, I'll ask Laura to drop a link to that in chat. We're going to go for an evening session this time, just to see if some people who haven't been able to attend can then attend. And finally, do fill in the feedback form, please. So I am absolutely delighted to quickly move on to introducing our speakers, so you don't have to hear from me anymore. First up is our very own Kate Ewing. Kate is a researcher at Just Fair, and alongside her work with us, Kate is working on a PhD at Pompeu Fabra University in Barcelona. The focus of her work is work time and minimum wage, and Kate previously worked in London as a labour rights solicitor representing trade unions and their members. So over to you, Kate.
Thanks very much, Helen, and hi everybody. It's really nice to see so many people on the call today. I will start by trying to share my screen. Let's see, there we go. Right. Hopefully everybody can see that okay. So I thought I would sort of just start by introducing the session today. As Helen's mentioned, this is one of a series of events that Just Fair has been organising to discuss incorporation of everyday rights into everyday life for everyone in the UK. And so when we talk about everyday rights, what we mean are things like having a decent job, having a place to call home, a place to learn and pursue education, good physical and mental health, amongst other similar things. And by incorporation, we mean not only the legal frameworks that are needed, but also all the policies and mechanisms that surround that to make sure that people actually experience their rights in day-to-day life. So these sessions are really an opportunity to think about how we bridge the gap between the promises of the international legal protections that already exist and the reality as it's being experienced by people in their day-to-day lives across the UK. And so as part of that, Just Fair has developed 5 principles to help us think about this and guide the discussions that we're hosting. And we hope that through this process, we can gather together all of our expertise and ideas to think about how we can best achieve the goal of rights incorporation in UK law so that people are actually enjoying their rights in reality. I'm not going to go through all of the 5 principles in detail. You can see them on the screen. What I would do is encourage anyone who hasn't been to previous sessions to check out our online resource page, which has recordings and information relating to the sessions that we've already had, and also, of course, sign up for the upcoming sessions. But very briefly, the 5 principles are rights knowledge, rights frameworks, rights resourcing, rights accountability, and rights enjoyment. And so the focus of this session is, of course, on that 3rd principle, rights resourcing. So, what do we mean by that? Well, what we would like to do is to explore and talk about the proactive resourcing of the rights themselves. So how can we guarantee everyday rights like health, social security, housing, an adequate standard of living, education? And how do we make sure that the UK government makes the best use of the available resources to do this? And we don't want to wait for things to go wrong, for people to experience a failure to protect their rights before any tangible action is taken to keep trying to improve people's day-to-day lives. So how do we ensure that rights protection is an ongoing process, and there are systems of review to ensure that there is progress and proactive improvement? What would that involve and how would it work? But of course, we have to be realistic that there will be, and there are, situations where things do go wrong. And that means there needs to be complaints and monitoring mechanisms so people can challenge decisions and failures to protect their rights and seek remedy and meaningful change. So how should that be resourced? and resource in a way that makes sure that it's accessible for everybody. And how do we make, I mean, basically we're thinking about how do we make complaint systems effective and actually work for the people that use them. And so I think that leads to a sort of just final thought from me, which is, what does that word resource and resourcing actually mean? We can think about it in terms of financial, you think about it in terms of finances, so, paying for things, funding things. There's the legal resources, so having the laws and the accompanying systems. But what we've also been talking about in Just Fair is the importance of recognizing and supporting the emotional resources required and involved in challenging failures to protect rights and seek accountability and change. So there's really a lot to think about and lots to talk about. So I'm really, really looking forward to today's discussion. And I think with that, I'll hand back to you, Helen.
Thank you so much, Kate. And with that introduction, I think you'll probably be able to guess why we have invited the 3 guest speakers we have. So just moving quickly onwards so that you can hear from them. I am absolutely delighted to firstly introduce Sara Hall. Sara is a Deputy Director, External Affairs at Tax Justice UK, and she has over 2 decades of experience leading and winning campaigns at the national and international level, with a strong track record of leading powerful coalitions and building broad movements with a focus on impact. Previous positions include leading campaigns on Europe at the Amnesty International Secretariat, leading Stonewall's international campaigns and policy work, and developing powerful campaigns at Save the Children UK. So over to you, Sara.
Thank you very much for having me. It's really, really nice to be in this space with you. I'll try and share my screen as well and hope this works for you. Slide. Great. Wonderful. Can you all see that? Yes, amazing. So, yeah, just a very brief, thank you for the very generous introduction, Helen. Just a little bit of introduction about, Tax Justice UK. We do what it says on the tin, really. We are a campaigning and advocacy organization, and we want to ensure that everyone in the UK benefits from a sustainable, fair, and effective tax system. We have 3 pillars to our work, really. So one is that we're helping to build a broad movement of groups and credible voices backing reforms to the tax system. So it's a strand I've been leading since I joined the organization. So thank you for inviting me in this space. I'm always really interested to connect to different areas. So it's wonderful to be here. We also try and help shape a public and media narrative about what a fairer tax system looks like. And, as you would expect, more traditionally, we work with politicians to build support for the wide-ranging reform that is needed, while also looking for short-term wins, short-term opportunities for a quick campaign win. We never say no to that if we can. Sorry, before I move us on to a wonderful picture of the Prime Minister, I just wanted to say I've been asked, as you would expect, to speak about where's the money, because I think many of us are routinely told in our work, oh, nice idea, but we can't possibly fund this. So I have some ideas how things might get funded. What I should say before I get into some of the detail is the government has many levers to raise funds. Tax is just one of them. So I wouldn't want to advocate, that everything needs to be funded by the tax system. There are lots of other avenues you have available if you're a national government. We're not like a household, the housewife elegy that, you have to have your, you can't max out the credit card, all these kind of really unhelpful narratives which have creeped into the public narrative. This is not how an economy at the national level works, and tax is one part. So I think I need to say that, but because I work for Tax Justice, I have some ideas where money could be found, and also would make the UK a more fairer and equal country in the process. So what's not to like? One area where there's huge potential and where the UK is currently really quite unequal is around taxing wealth more. So for example, in the UK currently, income from work is taxed at a higher rate than income from wealth. So if you go out for a living, you're likely to pay a higher tax rate, especially if you're in the higher income tax bands, than if you don't work and take all your income from stocks and shares, for example. And our Prime Minister Rishi Sunak is a very good example of that. So last year, we analyzed his tax return. So last year he earned 2.2 million. The vast majority of this income isn't from his salary as a prime minister. So it's from investments, etc. So this is 2.2 million in 1 year. And he paid a 23% tax rate on all his income. So this is the same tax rate as an average teacher. You might join me in asking how, why is this fair? Does this make sense? So together with the Patriotic Millionaires UK, we're campaigning, really to change the system. We've put together a platform of 6 wealth tax policies that we would have calculated would raise about £50 billion per year. So one would be a one-off annual wealth tax, so that, if you have assets over £10 million, you would pay 1 to 2% wealth tax per year. Only over assets over 10 million. So if you have less than 10 million, that would not apply for you, to you. That would raise about 22 billion pounds a year. If you would equalize capital gains tax with income tax rates, so basically taxing income from work at the same level as income from wealth, that would raise about 15.2 billion a year. And I was told not to put anything on the slide, which I don't read, but I feel the time pressure. So just apologies for that. But just to say there are other, a lot of other reforms which would also raise billions. We're not currently implementing or even considering implementing. Apart from taxing wealth, there is a lot more which can be done. For example, closing tax loopholes. This isn't a typo. There are 1,180 tax loopholes in the UK, and the government only knows the impact and cost of 365 of them. It's, in my view, really quite mad. So we estimated, we're a small NGO, we couldn't possibly analyze over 1,000 loopholes, but we estimated that closing just 5 tax loopholes per year could raise £7 billion. So that would include ending fossil fuel subsidies for oil and gas companies, which would raise 4.4 billion a year. There is a classic car exemption. If you own a classic car, you don't pay vehicle excise duty for whatever reason. That would raise 130 million pounds a year if you would close that loophole. There is tax relief on video games. You could raise 197 million a year, and there are other loopholes in capital gains tax and also in inheritance tax, which also would raise over £1 billion a year. The cost of tax reliefs are really huge. The National Audit Office estimates that the cost of tax relief is over £204 billion every year. That is not to say that this over £200 billion every year is totally wasted. There will be tax reliefs which make sense, which are probably useful. They are used by the government to try and encourage certain activities or types of investments. But because HMRC is so under-resourced, it's currently not clear if the tax reliefs are working as intended or not, because they have only assessed a tiny fraction of tax reliefs over the past 9 years. So without that assessment, we can't possibly know if most of this 200 billion pounds a year is put to good use, and if it's value for money, if it's working as intended. One of the tax reliefs HMRC did manage to assess is research and development relief for smaller businesses. And this was basically being claimed fraudulently or in error a quarter of the time. So from this one tax relief, there's like over £1 billion a year that was claimed wrongly. So there are potential huge losses in this unknown number of tax reliefs. So yeah, we need to invest in HMRC to sort this out. The tax gap also between what HMRC expects to receive and its actual receipt increased to 36 billion pounds last year. Again, sorry, I put too much writing on the slide, but really the one key thing is to properly resource HMRC, and then there are other measures you could take to really crack down on this tax gap. Then we have international tax avoidance, which unfortunately the UK plays a leading role, because the UK, together with its network of overseas territories and crown dependencies, is the world's greatest enabler of global tax abuse. So one primary way in which the overseas territories enable tax abuse is by allowing businesses to use shell companies to shield the true identity of their owner. And they really should be required to introduce public registers of beneficial ownership, so public registers who actually owns these companies. And they promised to do this. The deadline was the end of last year, and progress has been absolutely painfully slow. Only Gibraltar has published this, and we've just released a report last week on how painfully slow this progress is. I can share a link in the chat after. So huge amount to be done here. I'm coming to the end because I'm probably running out of time, but there's also something like called country by country reporting, which requires large multinational enterprises to report an annual breakdown of key elements of their activities in the jurisdictions where they operate. And this provides tax authorities with visibility of where the revenues, profit generated, and tax paid on a country by country basis. This data is currently shared with HMRC privately, but it's not publicly available. So there is no scrutiny to really see that. So yeah, it should really be a requirement to make this data publicly available. And if you think this is a very bleak picture, I can end on a note of hope. There's been some really good developments at the international level lately. We now see moves to establish a UN tax convention. So this would provide a global structure at the United Nations to negotiate international systems change on a level playing field, and crucially involves the whole world, not only wealthier nations. The UK has played, unfortunately, a key blocker role in trying to establish this UN tax convention. They were the country who tabled a motion at the United Nations to remove the word convention from the convention. But luckily, I think for all tax justice campaigners, this was defeated. But lots of work to be done in the UK, that's for sure. But we can do it. We've made progress. Wealth taxes are now part of the conversation. We've seen, in my time at Tax Justice UK, government U-turns on a global minimum tax deals, measures to tackle economic crime, and a windfall tax on oil and gas companies, even though there are loopholes in this tax. We work to create progressive change, a more progressive narrative on tax. But really, the global game changer, I believe, will be the UN Tax Convention. And there's lots of work to be done. We have an election this year, we expect. Yeah, we will continue to work with a new government to propose progressive tax reforms as one of the solutions to raise revenue for spending on Britain's many compounding crises like climate change, public service erosion, etc. So thank you very much. I'm sorry if I went over time. We do have a weekly newsletter you're welcome to sign up to, or you can take action on our website. So the links are there. I can put them in the chat as well. Yeah, thank you for having me. Looking forward to the conversation.
Thank you so much for that, Sarah. And yeah, a lot to think about and digest, particularly when we're told there's no money for change. So just to let people know, all slides from our speakers are actually already on the resources page that Laura dropped into the chat earlier. So don't worry about me sending them out, they're already available. And also, Sarah, I believe that report you mentioned is already up there as well. So thank you so much for that. So wonderful from Sara, and then we're going to move quickly on to Saba. And Saba Shakil is a research fellow at the Public Law Project, a charity that seeks to increase access to justice through casework and research. Her primary research interests are judicial review, delegated legislation, and human rights. So I'm just going to pass straight over to you, Saba.
Thanks, Helen, and thank you everyone for Just Fair for having me today, and for Sara for setting the stage beautifully, because now that we know that there is money going around, the real question is, where should it be going, right? So as Helen said, Public Law Project is a national charity that seeks to increase access to justice through a combination of casework and research, and through that we aim to influence policy and lawmaking. We have 5 key priority areas. Let's see if I can remember them all. The first of them is constitutional reform. Then we also look at the law and technology. We look at welfare benefits, legal aid, and immigration. And so my presentation today is going to be focusing primarily on the 4th of those, which is legal aid. And I think it's no surprise, or no, it shouldn't come as a surprise really, that human rights have come under attack over the last few years. You know, they've been perceived as a hindrance to the operation of the state, and there's been a kind of narrative trying to dissuade individual reliance on them. And we see this in some more overt ways. So, for example, the narratives around the Safety of Rwanda bill now seem to be an act, unfortunately. And a lot of this dialogue around, you know, stopping the boats and the role of foreign courts and interfering in the UK's processes, hostility against the European Convention on Human Rights. That's one form of quite obvious narrative against rights. But there's another more covert way in which you can strip individuals of their everyday rights, and that's the failure of resourcing the enforcement of rights. And I think, you know, Sara's very much hinted at this. Resourcing really is a matter of political will, right? It's a matter of rights. It's not just enforcement has a very intimate relationship with, you know, the rights that it seeks to protect. So Article 6 of the European Convention of Human Rights entitles everyone to a fair hearing. And as part of this, the European Court has, you know, read into this right that a state can be compelled to provide for the assistance of a lawyer when this is indispensable for effective access to the court. So that's one way, you know, enforcement and resourcing of these rights is built into the rights themselves. But then on a kind of more social level, it's a matter of, you know, remoteness and closeness to rights. People feel distanced from the rights that they don't have the ability to enforce, right? So when we're talking about what everyday rights in the UK should look like, it's not just about looking at the substantive rights and their contents, but also how we're going to enforce them. And currently, enforcement of all rights is being hindered by a really severe legal aid sustainability crisis. And I'm sure, you know, again, this won't come as a surprise to many of you who are probably working in these fields, but there are the introduction of the Legal Aid Sentencing of Prisoners and Offenders Act 2012, or LASPO, came into effect in 2013 and has really essentially slashed away at the legal aid budget of this country. So it's done this in two main ways. Firstly, the scope of legal aid has been reduced drastically. So most family, housing, debt, welfare benefits, and employment matters are currently excluded from the scope of legal aid. And then there are eligibility requirements. So essentially, it's become more difficult to qualify financially for legal aid. And just to give you an overview of the kind of crisis this has produced in the availability of, legal aid, currently in the field of education, 9 in 10 people across the UK do not have access to a local education law provider. In terms of housing, 44% of people do not have access to a local provider. And for welfare benefits, 85% of people do not have access to a local provider. These are figures that are quite well known. The Law Society has done a lot of research into legal aid deserts, and yeah, very accessible information, but I don't think that makes it any less shocking to hear. So what are the main kind of issues? And I'm only going to give an overview because, we'll be going into solutions a bit more later, but it's an incredibly administratively complex system, the administration of legal aid, and that has real consequences for providers who face huge burdens in maintaining their legal aid contracts and keeping up with the associated billing and auditing processes. And then on top of that, compliance activity can be disproportionate and punitive. So where providers, may fall short on really minor kind of technical errors, they can be quite disproportionate sanctions, and these can create financial risks. And then when you pair that with the fact that all civil legal aid fees were cut by 10% in 2011, but otherwise hourly rates have been frozen since 1996, this is not a sustainable business. It's not sustainable for providers whatsoever. And the result is you have wider social and economic harm being caused by the fact that individuals are either struggling to obtain legal representation, or where they are, they're in a situation where their provider may be overburdened and under-resourced, so is at a risk of providing a substandard service. And that's just looking at, the technical administration of this policy. We're not even getting into, yet the emotional cost of claimants trying to bring these cases. So that was quite bleak. But like Sara says, the things that we're talking about here, legal aid, it's not the be all end all. It's not the end of rights and resourcing rights and enforcing them, but it's an existing system that we have, that, there are a range of short, medium and long-term things we can do to improve this system. There are other mechanisms of accountability that exist in our constitutional system that we need to explore. So yes, the image is quite bleak, but I think it's important to acknowledge that bleakness. And, if we're going to push for the recognition of more substantive rights in the UK, it's, unfeasible without thinking about how people would actually enforce those rights. And in the system we exist in, legal aid is a huge part of that.
Thank you so much for that, Saba, and don't worry about being a little pessimistic. I think I had really invited you here expecting that it might be such a picture. So from Sara talking about how the money does exist if we wanted to Saba talking about people feeling remote from their rights, including through the current legal aid crisis, I'm delighted to invite our final guest speaker, to talk a little bit about the actual experience on the ground of resourcing your rights, including that kind of, as people have hinted at, that kind of emotional, although that's not all you'll speak to, I'm sure, Emma. So I'm delighted to invite Emma Morgan. Emma is a co-founder of SEN Reform NI. It's a parent-led advocacy group campaigning for equity in the education system in Northern Ireland. The group aims to represent parental lived experience of the SEN education system to influence systemic changes. So Emma, delighted to invite you to speak, and I'm going to share your PowerPoint.
Thank you, Helen, and thank you to Just Fair for inviting me here today. So I'm coming at the perspective of rights from a what goes wrong point of view, I suppose. As Kate had said at the very start about the day-to-day experiences and the difference between the reality of how rights are experienced in everyday life. I suppose that's where SEN Reform NI has started. There were similar movements in Scotland and England. Northern Ireland, I would argue, is in a significantly worse position with regards to the rights of children who have disabilities and additional needs, which is referred to as SEN, so special educational needs. In Northern Ireland, we have had quite difficult political and social context, and that's had an impact on our education system. So I suppose the next slide then, Helen, outlines where my personal journey with this started, because it's sort of linked with personal, social, political, and it all really has come together in the last year. That's my little boy, Tom. He is now 5 years old. Tom is autistic and has learning difficulty. Tom was refused attendance at a local mainstream school due to the level of support he required. And for us as parents, that was a big shock. We had professional reports from educational psychology to say that Tom should attend the school. However, the reality of Tom attending a large class size with 30 children would have actually been impossible for him with the level of support he required. Due to the lack of SEN placements, Tom then had to attend a private SEN nursery. With regards to resourcing of Tom's rights, we had to pay the cost of that. As a family, I had to come out of work as a teacher and support my son with that. He had a 45-minute journey to and from school at a cost of £550 for 3 days. So the reality of my son being able to attend school and get an education is very, very far removed from the reality. To attain a statement of educational need, in Northern Ireland, it's called a statement. So I think it's an EHCP in England. We had to go through 2 legal tribunals. We had to get a legal aid solicitor for that, so that linking to Saba, and we also had to go through 2 legal tribunals with a barrister at the cost of £600 for each tribunal. With SEN Reform NI, we did a quick survey of parents. Of 100 parents, 70% said they had to get legal support within the process of getting a statement for their child. So in Northern Ireland, it is nearly accepted that if you want to have sufficient support for your child, you need the help of a solicitor with that. It is nearly an impossible route to navigate by yourself as a parent. MLAs at the time had very little control or influence. We tried to lobby our local politicians individually as parents at this stage. However, with there being no sitting Stormont, no executive to make decisions on the education crisis, it was being managed by a public body, the Education Authority, without any scrutiny. For P1, we had expected that it would be smoother, because in Northern Ireland, P1 is a statutory obligation, so the legal right to education is protected at the stage of P1, whereas in nursery and preschool it is not. However, that did not go smoothly. Again, we had to what parents refer to as a fight the system. It's a continual fight in Northern Ireland to try and get support for your child within school. We ended up then forming SEN Reform NI in May of last year. We protested outside Stormont, and it was only after that and significant coverage with BBC that my son was offered a place. So following an interview on Newsline 6:30, my son was offered a place the next day. So that was the situation of rights within Northern Ireland last year, and this year is much the same, unfortunately. The social context of having no functioning executive in Northern Ireland had a huge impact on all of these issues. Funding in relation to the budget as well, which was imposed by Westminster in Northern Ireland, had significant impact on education within special educational needs. So next slide, Helen, please. So as I said, SEN reform began in June 2023 as a protest of several hundred parents, and our aim was to represent the lived experiences of parents and what it was like really on the ground, because we found that there was a huge disjoint between what was being said publicly by our political leaders, by the leaders within the civil servants, and the scale of what was actually happening on the ground. Our view was that our children had a legal and human right to education, whether they had a disability or not. They should be able to attend a local school, and they should be able to do so without the fight, as parents call it. That was very far removed from the case. My personal view is that because children with disabilities are in the minority, that it nearly became accepted that this was what happened year in, year out. The problems and difficulties that were faced to try and get an education for our children, it was a circular problem. It went on year after year, and as the children got placed in maybe an inadequate setting, that was all swept under the carpet. So currently we have over 1,500 supporters online. There's a petition of 16,000 signatures calling for systematic reform of SEN provisions in Northern Ireland. And we're also formalising as a charity this year and applying for charity status. One of the important thing to mention is Northern Ireland per head has the lowest rate spend on education than the rest of the UK, but Northern Ireland has the highest rates in SEN within all the UK, and last year saw a significant rise in the number of children with SEN and complex needs. So that's really with the culmination of everything that was happening politically, with the type of child that was coming through the education system, the level of disability and the complexity of their needs. All of this culminated in what was called a crisis within our education system. So Helen, the next slide is about our aims. I'll not go through this because I'm probably running out of time. Really linking to rights resourcing, our view is the education system should be fulfilling its statutory obligations and fulfilling the children's right to education. That is really what SEN reform is aiming to do, to try and influence change within the education system so that children with disabilities can access an adequate education. And I suppose that use of the word adequate really highlights where we currently are at. We are very, very far from enjoying an education in Northern Ireland for children with disabilities, and that is not right and that is not okay. But the current situation is dire. Sorry to be negative. Working with stakeholders is a key concern for SEN reform, and we've met with the Minister for Education, we've met with all of the senior civil servants responsible for this. We have given evidence to the Education Committee. So we're trying our best with very limited resources with time to do so, because there's 4 of us running this campaign, and all of us have at least one child with a disability and that has significant level of need. We have run with 0 funds to date. So it has been challenging, but in the last year, we've been really surprised at how far we've been able to come. Next slide, Helen. The media has been a big support for us. Really, what we're trying to do is highlight the issues that families are facing, because as I said, our children are in the minority, and children with disabilities and their views have not been represented in Northern Ireland. So we have tried to have widespread media coverage as much as we can about equity of access to education. We have also given evidence to Westminster, to the Northern Ireland Affairs Committee. We were invited to give evidence on public spending within Northern Ireland, and recommendations were made with regards to SEN. As I said, we've lobbied MPs and had lots of meetings, and currently applying for charity status. So that's where we're currently at the minute. It is very much a grassroots campaign that has considerable support within our community, but for us, resourcing is huge from the perspective that we have to make decisions about how we can best manage this situation. And we do feel that as a new grassroots campaign, we are meeting barriers with regards to how to negotiate the system as well. It has been very challenging to be met with answers that are not connected to reality. I hope that makes sense. So the answers that we have been given are very much removed from the reality of what is happening on the ground. So we will continue to go and try our best to advocate for our kids. And what needs to change then, Helen, is one of my last slides. We're calling for planning for placements for children with additional needs and disabilities. At the minute, the current basic of being able to access a classroom, there are hundreds of children in Northern Ireland that are staying at home and not having an education because the placement they have been given is not appropriate. There have been numerous reports to say that early intervention does not happen in Northern Ireland. So that is a key priority for us. Systematic reform is our long-term goal, and we are working with the Department of Education for a truly inclusive education system, and that is a whole can of worms in itself. Realistic funding is a huge aspect of this. Currently, the budget for Northern Ireland is to be released today, and the Finance Minister has said there's a 2 billion deficit of what is being asked for against the actual spend. So that leads to what Sara has been talking about, that there does not appear to be the money, but even the money that is being spent is often being spent inefficiently in a public body that lacks scrutiny. So there are a huge array of issues, and what I always say is we're just parents, but we're trying our best to be advocates with regards to this. And my final slide is about inclusion. So for the future, inclusion isn't just inviting someone to sit at your table, it's believing they belong there. And in Northern Ireland, our children are not being invited to sit at the table. So we haven't even got to the first step. And really what we need is a cultural change within our education system. But our values in SEN reform are based on respect and working together. So we are hopeful for the future. One of our MLAs described SEN reform as turning a tanker in a road, that it takes little steps to happen very slowly. My patience isn't holding out on that, but I'm hopeful for the future. Thank you, Helen.
Thank you so much for that, Emma, and for such a comprehensive view of Northern Ireland. And Emma is not joking when she says about utilising the media. It has been a delight to know Emma from a previous life and to hear her advocating so wonderfully for her family and for lots of families across Northern Ireland. So thank you so much to each of our 4 speakers. You have all been so absolutely fantastic, and I'm delighted to enter the next discussion section. So as Kate so wonderfully outlined earlier, we are going to be looking at the issue of rights resourcing. And to do so, we have probably about 7 to 10 minutes to talk through each of the bullet points you folks were sent in advance. I am just going to copy and paste the first bullet point actually into the chat so that we all have it for reference. But the first bullet point is, what resources for protecting rights already exist but aren't working properly or aren't being used properly? Are there examples of resources which could be made more effective, more protective with minor amendment or with different implementation? So I'm throwing that question out to the floor. If anybody either wants to raise their hand and I'll call on you to speak, or if you want to drop something in the chat and I can read it out for you if you prefer not to speak. But over to the floor for that first question.
I'm happy to, although I will say, despite the fact that the majority of my initial presentation was about legal aid, I'm actually saving the big changes there, I think, for a couple of questions down. But there are some kind of immediate, short-term changes that we can make. So like I was saying, fairer remuneration for providers in order to stop them from kind of draining out the system. and things like, you know, passporting through the income test for legal aid. So if you're already eligible for benefits and the state's already kind of assessed your eligibility, that should extend to both, you know, not only the income means test, but the capital means test. But kind of looking at other resources that exist within the system that could be made, you know, more use of. They're not as, you know, sexy as some of the other means of enforcement, but you know, the ombuds and ombudsman, and you know, the core function of these ombuds is to investigate complaints from individuals about maladministration by public bodies. But they are starting to develop a role in ensuring that these public bodies also don't neglect human rights. So, for example, the local government and social care ombudsman looks at local government maladministration, but really what they're looking at are crucial kind of ESCR issues, right? So they're looking at things like adult social care, support for children with SEND, you know, needs, schooling, libraries, homelessness, housing support. And they're starting to, you know, develop a kind of jurisprudence around human rights and starting to incorporate that language into their work, which is, you know, really great to see. And it could just be that's a case of, you know, further educating these ombudsmen on, you know, international treaties that could be woven into their findings and help influence their decision making. So that's quite encouraging to see. Or, you know, things like removing the need to go through an MP to access the Parliamentary and Health Service ombudsman, and, you know, referring more directly to human rights in ombudsman statutes, working more closely with, you know, various bodies like the Equality Human Rights Commission, develop guidance. So yeah, this is me trying not to be as bleak as I was earlier on. There are things we can tap into, I think, that would kind of push us a bit more forward.
Thank you so much for that. And Emma, I know you want to come in and I'm going to call you in a second, but I wondered, Kate, after that, because I remember you in our SESCA report writing something similar around minimum wage enforcement, but I'm going to leave that with you, Kate, and maybe call on you after we go over to Emma.
Hi, yes, I suppose what isn't working properly, the guidelines are there, we're saying, and local solicitors who are dealing with these issues on a day-to-day basis and experts in the law locally are saying that the problem is not necessarily with the guidelines. In Northern Ireland, the guidelines are quite good. However, the problem is the implementation of the guidelines. Views from parents seem to represent that the implementation and the ability of service users, i.e. parents and carers, to use and work through the statutory assessment processes that help to get supports for children with SEN, are they don't follow their own guidelines, that deadlines are missed, that are statutory obligations, and there are no checks and balances really in place for the work that the public body governing the education system is putting out. So the legal documents that are being produced are often defective, and they have no really legal depth within them. So that's one of the key problems that is coming through, that the public body is there and operating on with a lack of scrutiny from anybody else. So the Department of Education in Northern Ireland produces the policies, but there is no scrutiny role. There is a capacity for it, but it is not currently happening. With an example of that would be that with the production of statements of educational needs, which is a legally binding document, they are produced with no level of oversight. So a statement officer, which is an administrative level, produces the statement, but there is no checks or balances on these documents at all. So we have called for the Education Authority to have nearly like a verification of these documents, so that they do have the capacity, and they used to do things like this, but currently with resources internally in the public body stretched with high levels of absence, there has been limitations to that. So there are things that can be done, but it seems to be, unless they're being called for publicly, it may not happen.
Incredibly frustrating. Kate, are you okay for me to call on you after dropping you in it?
Yeah, no, that's great. Thanks very much. I think it's really interesting that you both sort of, the thing that came to mind when both of you just spoke then was how there's this real sense of things are just not joined up. So there may be elements that technically could work, but for various different reasons don't work because either the system's too difficult to navigate or it's too difficult to access, that the individual mechanisms within the system, they don't work, and so you miss the elements that add on top of each other. I think like my background is more in terms of workers' rights, and the thing that used to be intensely problematic is just a lack of proactive enforcement of things around the minimum wage. So HMRC wasn't adequately resourced and for enforcing the minimum wage. The tribunal process is difficult to navigate, like you've highlighted, Emma, if you don't have access to legal support. And as Saba, you've highlighted, there's no legal aid for that. And then the mechanisms within the legislation as well are problematic in terms of the kind of records that are required to be kept, which you need access to be able to prove it not being paid, because the information isn't always proactively provided by an employer. So I think that's the point that seems to be really important, is that you can have things that on paper that may technically seem to be there, but at the moment there just seems to be a lot of cracks between all of that, and that just makes it more and more difficult. So there are many aspects that need to be resourced. So it's not just about providing a piece of law, it's not or a piece of guidance, or indeed even legal aid. It's about all of those things being able to connect together. And as you said, exactly, like the rights being enforced are critical. So you need to proactively fund the rights, but you also have to proactively fund an enforcement mechanism that is accessible, that is possible to navigate, that doesn't require people to go knocking on 50 different doors to try and work out how they resolve an issue, whilst they're also living with that issue day to day. So I can only really agree with everything that has been said, and I'm trying really hard not to sound like the voice of doom as well. I think there's a lot of work to be done, and it's really good that we can have these discussions to sort of work out where to start, I guess, or where to keep building.
Thank you so much for that, Kate. And I know, Sara, you want to speak a little bit about council tax, and Anna, I see your hand up, and then we'll maybe move on to the next point. But I did just want to say, like, exactly what you folks are saying is the very nub of why we want to have these conversations when we talk about incorporating these rights, so bringing them home. We want it to be so much more than just bringing laws in, but actually they need to make a difference in how people live their lives and how they experience these things on the ground. So that's exactly where we're doing this scheme of work. So thank you all. Sara.
Yeah, just to say a big area I should have probably mentioned in my presentation, but I barely got through all the other big areas on tax justice in the time allocated is I think we do need to mention the role of local authorities. Local authorities are totally cash strapped and have been starved of funds for so long, yet are at the grassroots of at the local level of delivering such vital services. So I think that's a really important aspect. And in addition, it really doesn't help that council tax is completely broken. It's a completely broken system where there's absolutely no political will to try and tackle it, even though it really doesn't make sense. Apart from the revenue raising aspect, it's also so deeply unfair. You can have a big, fat, wonderful house in Mayfair, and you might be in the same, council tax band as someone in, I don't know, the north of England, a much smaller, much cheaper property. So yeah, there is huge need, I think, for reform at that local level. I can recommend a really good campaign called Fairer Share, which is a campaign for proportional property tax to really reform the council tax system and replace it with a proportional property tax. That might not solve all the issues of local authority funding, but it would certainly be like, you know, one step in making the system much fairer. I'll post it in the chat.
Thank you much, Sarah. Thank you so much, Sarah. Anna, did you want to come in?
Yeah, so me and Michelle, who's somewhere on the call, work for a consultancy around learning and systems, and been focusing quite a lot on housing, and particularly Greater Manchester and a project there. And echoing quite a lot of what people have said, I think it's the resourcing. So if we look at sort of rogue criminal landlords, as you would say, usually you have really vulnerable tenants who are kind of, there's a real power imbalance, and they're really worried to report. But even if they do report, the resourcing for enforcement from the council is really low. And then it's not even the resourcing, I think it's the training of people adequately to deal with that situation and deal with that power imbalance and deal with the vulnerability that's there. And I know Shelter in Manchester are kind of working with the GMCA at the moment to sort of talk about what would a fining system look like as opposed to a straight to court. Would that be able to kind of cover some of the training and stuff that would happen? Would that be more effective? Would that be more of a deterrent? And just to kind of loop back to someone's point at the beginning about ombudsmen, I think they have a huge role in housing, but if you're a tenant, you're not very engaged, it's sort of rightly so, you've got loads of other things to be getting on with. Usually the first thing you'll kind of know is the deposit security scheme. But actually that organisation does loads more. They do loads of negotiation between stuff. They're a really safe pair of hands to go to, but that's not widely known. So there's all these, I guess, all these sort of intersecting things coming together that make it really hard for kind of tenants' basic rights to be enacted. That's our experience.
Thank you so much. That's a really great contribution, Anna. Sandra, I want to move on quickly to the next point, but do you want to come in and make your point?
It wasn't going to be very short, actually. Shall I just leave it?
Go for it, Sandra. Go for it, sure. Well, I'm pasting it in the chat. You go ahead, Sandra.
Okay. It's I've been in the youth justice system for 15 or so years, and sorry, I've forgotten her name. The lady who's running the campaign. It's the two things in England, hopefully, presumably it's the same, they're absolutely related. So if you have SEND, then you get into trouble, the police pick you up, and it's an ongoing thing. But there is hope. The point is that the youth justice system in Northern Ireland, as well as in England, we've learnt over those 15 years that if you are strategic about these things, it's not a question of every single child has to go to a tribunal and get a case heard. It's a question of being strategic about it and getting one case judgment in your favour, and then using that as a precedent in other cases. And that's how we've worked in the youth justice system, for example, with keeping DNA samples when you're in children. It took a long fight, had to go to the European Court in the end. But that one case had so many wins down the line. So I think that's the approach that is needed. It's simple and damned cost effective, especially for people who have no access to funds to bring about individual cases. But yes, so it's up to you, Helen, to put that in place. How to get the strategic litigation going, and then spread the word out to other areas, and everybody's fighting exactly the same battle. That is my point.
Thank you for that, Sandra. So a point about strategic litigation, and of course in Northern Ireland we do have the Public Interest Litigation Service, PILS. So I'm going to move on quickly then to number 2, because as always we are so good at discussing these. We're running short on time, but it's all good. So what are examples of good practice or good initiatives that we are aware of and could use to build upon? We're interested in where these are happening, how they are working well, and why they are working well. Anybody want to kick off on that one?
don't mind jumping in briefly again, sorry. So I've been working on a project called Fair Housing Futures in Manchester, which I don't know if anyone's heard of it. It was a 6-year project that had some landlord groups and tenant groups and sort of groups that sort of supported people with homelessness, as well as the Greater Manchester Local Authority. And out of that has come sort of, that partnership was carried on inside the GMCA when the programme closed, and now they have managed to put together something called a Good Landlord Charter, which I think is coming into effect in November. And that is quite a lot of large landlords signing up to this kind of code of conduct, and they get a version of an accreditation that's recognised across Greater Manchester. And usually housing is quite a bleak place to work in, but I'll take the glimmers of hope where that can be got. And I think it, it doesn't go maybe as far as some tenants groups would like in terms of rent controls or things like that, but it does focus on things like enforcement, direct payment of DSS where people might want that, ombudsman stuff, fine. So it's and actually for a place-based approach that's working quite well. It seems like it works because it's specific to Greater Manchester and there's quite a lot of political will there anyway. But that's something that has cheered me up a bit over that. So share that with you as something that's going in place, along with people like Acorn. I think we're quite involved to a kind of tenants' right group, so they're really good at working with GPs and people like that to signpost tenants towards their rights. So trying to figure out where most vulnerable tenants would naturally be picked up and would be recognised as being in poor housing, and then using those kind of points, so schools, food banks, GPs, to signpost towards kind of rights and support. So yeah.
That's wonderful, Anna, and just really, really sensible ways of going forward, and that place space being important, I suppose, as well. I have a comment from Samantha here. I think charities and voluntary organisations have a role to play in educating their stakeholders in their rights and helping people to enforce their rights as well as enforcing on their behalf. We need a culture of a rights-based approach in those organisations too. This is obviously resource dependent, but a start would be prioritising this approach within organisations. And Mikey from DR UK says, on the first question, I wanted to understand why people felt confident in well-resourced ombudsman as a route to enacting rights. Maybe come back to that in a second, Mikey, because I know Lydia and Jackie both want to come in. So could I pass to you first, Lydia? And perhaps while that's happening, one of our panelists might want to think of a response to Mikey.
Hi everyone. I work for in the bit of the migration sector, which is supporting EU citizens and their families after Brexit. And what a kind of good practice, not to ring my own bell or whatever, but I coordinate a civil society EUSS alliance, which is UK wide, and it's made up of a really mixed bag of players within the sector. So grassroots, legal specialists, kind of high level and grassroots coming together once a month to share issues and communicate with each other in a kind of more informal way. But we also invite institutions in, so we have the Home Office in to kind of update us on changes in policy, or the EU side, EU institutions coming in. And although, ostensibly it's a kind of networking space, in fact, what's happening is that we're becoming quite a significant sort of voice. And it means that we're more informed than a lot of kind of individual associations or legal practitioners. But out of that, just to return to a previous comment about strategic litigation, what's happening now is we're pushing ourselves to think about collective action on, access to rights and justice for our clients. And so strategic litigation is becoming a big focus now. But also we've been lobbying, funders, embassies to really understand the issue within the sector and obviously who our client base are, but without the sector, those clients' access to their rights and justice is completely limited. So we're kind of going on the voice side of things, of really being able to define what our asks are as a sector and where the issues are, either engaging directly with the Home Office or government, but also going through monitoring authority, the EU delegation, and and independent funders to really be able to inform those who are supporting the sector and supporting EU citizens to really understand what the live issues are. And I suppose that, I mean, it's kind of, we're not kind of getting into really big pieces of work, but we are there as a consistent voice and a critical friend often to some of the institutions.
Sorry, what's your organisation, please?
So my organisation is New Europeans UK, but the Alliance is a kind of separate thing. It's called the Civil Society EUSS Alliance.
And Lydia, please do feel free to drop a link in the chat if you'd like to. Thank you so much.
Yeah.
Jackie, I'm going to pass over to you quickly.
Thanks very much. Yes, I'm here in a way wearing two hats. One is advice for renters, and the other is a small group that we run called Fairer Housing, which aims to involve people who are at the brunt of the housing crisis to understand the fundamental reasons for it, and to be calling for the radical changes that we need to end the housing crisis. I just really wanted to come in to respond to the comments that Anna was making, and to say that I hope some of you will have seen the publicity yesterday whereby the Renters' Rights Coalition and Shelter publicly announced that we are no longer supporting the Renters' Reform Bill because the government has not listened to any of the proposals we've made to strengthen it, but indeed has listened very carefully to landlords, including, of course, a lot of the government, members of the government itself, who are landlords, to actually water down the legislation. So if anybody is involved in that area, I mean, I would love to liaise with Anna anyway, to see how we could work perhaps with her group. But it is a good opportunity to expose the government's failure to do what it promised to do in terms of improving renters' rights, but also to be calling on the government. One of the reasons that I'm here today and been liaising with Just Fair is because Fairer Housing decided to make our asks during the general election under the banner of human rights. And although housing is a human right in theory, it certainly isn't in practice in the UK. And so I wondered, well, if anyone else is interested in joining us or contributing to that, that would be fantastic.
Jackie, Anna has just shared her email to me privately here, so I'll send that on to you in a little second. On Mikey's question about why we would trust a well-resourced ombudsman in terms of a way forward, do any of our panelists want to answer that quickly? Just recognizing we have 15 minutes left and 2 questions to get through. But any thoughts on ombudsmans?
Yeah. And I think it kind of it does go to, this theme that's been running through, which is like none of these things in and of itself is a complete solution to any problems. That it's not the case that in every single case an ombudsman will be able to get you. Sometimes you do need a decision to be directly quashed by a court, but at the same time, it's not that a legal remedy in and of itself will also solve all your problems. And for example, say a decision is quashed in the courts on the grounds that it was procedurally unfair, very open for the minister or decision maker, whoever it was, to then remake that exact decision. Now they know exactly the deficiency that got it struck down in the first place. So it's not, but generally, kind of just on the merits of ombudsman, even ombudsmen who don't have own initiative powers can still make recommendations that are more flexible than those of a court. So They can recommend financial compensation, which you will rarely get through judicial review, or they can make wider systemic recommendations about, a public body should be working with the Ombudsman to devise a human rights training program and collecting data. So it's, it's a more flexible system, and crucially, it's free. It's free to access, and has been said before, it's there, and a lot of the time it's an underused resource, and it's really, the kind of state we're in right now. I think it's about encouraging individuals, and again, not that they should have to, have the burden of doing everything themselves, but where there is something available to them that's free, and we can see there are smaller points where we can improve this system. I think there's not huge harm in encouraging, those routes of action.
Thank you so much. That for me was actually, I think I know a good bit about ombudsman, but that was a really great explanation. So thank you, Saba. Samantha, just before we move on, Samantha has put a comment in the chat. There's an organisation in disability rights space called Reasonable Access, which provides peer support to disabled people to enforce their rights under the Equality Act, which I think does a great job. Not a replacement for legal aid, but does help people to enforce their rights independently. And that's exactly the kind of examples that we're looking for. So thank you, Samantha. So moving on to the next point, we have what would good look like in this area? You can answer that in the short, the medium, the long term, but what would the ideal scenario be? Or else, what is one key change you would like to see, and what difference could it make? Does anybody want to come in on that?
Yes, please.
Where we get to dream. Go ahead, Sandra.
Yeah, I was going to say this in reply to Saba's earlier point. The problem with the ombudsman is that it's a case-by-case basis, and there's no join up, which is the one single thing that we need, especially in SEND. So if they start talking to each other, or talking, I don't know, publishing their findings and drawing the conclusions around exactly the same, sorry, I'm passionate about this, are exactly the same issues that every single parent on this journey has to fight, then those ombudsmen can empower us. But they don't at the moment. Why? God knows. God only knows.
Thank you for that, Sandra. And passion is very much welcome. Just to look to the good. So what would good look like? What's our ideal scenario? Jump in, Sarah.
Yeah, I think I outlined it in my presentation. There's just so much scope for a fairer and more effective tax system. And, whenever I'm in this kind of spaces like this, it really breaks my heart, to really see the suffering and the struggle, when really it does not need to be that way, at least not around resourcing. We are a rich country, and, those with the broadest shoulders, be it rich individuals or multinational corporations, just not paying anything like their fair share. And you could argue that, those with the broadest shoulders should probably pay more than their fair share, but they're not even getting close to paying their fair share. So for me, to really have wholesale reform on this issue, I think it would, make our country so much fairer, but also really, we're just hemorrhaging money, totally billions and billions, totally needlessly. And I think the question is like, if you could pick one, which would it be? It's actually really hard to pick one. Like, for example, if you have a wealth tax, but you're not cracking down on all the avenues for tax avoidance, there is going to be an ineffective tax. So I think, especially because we're so far behind anything like remotely looking like tax justice in this country, it would need to be really kind of broad scale reform along the things that are outlined. But it would be wonderful if we'd get there together one day.
Thank you so much. I'm just going to read out Mikey's comment, because although I think we need to move on from the ombudsman. I don't want to be not including everyone in the conversation either. So Maggie's saying, I guess from my perspective, the goal of ombudsman is and enacting rights doesn't match to me, as the role of ombudsman is to resolve a dispute, which means it will only ever work on a case-by-case basis, even if there are resolving many similar complaints, and very similar to what Sandra was saying as well, I think, and something that we have been thinking about a lot. I don't know if you're going to go on to this, Kate, but the fact that it's on the rights bearer, the person who, or sorry, the rights holder to make the change when something goes wrong so much at the moment, and that being problematic in itself. But over to you, Kate.
Yeah, sort of leading on a bit from that is that, you know, what good would look like ideally if we're at the like total dream stage is addressing that point that you're saying there, Helen, which is proactive rights protections, which mean that it isn't the responsibility of the right holder to hold people in power constantly to account to get their basic rights observed, right? So the starting point should be people enjoying their rights, and there being systems to, you know, I'm talking really sort of utopian stuff, but like properly enacted rights that people are actually enjoying, and they are being proactively monitored by systems to make sure that happens, with the safety net of when things, you know, where that breaks down, people have accessible routes for complaints and bringing about change. If we're talking about good in perhaps a slightly more practical way, but still very optimistically, I think, given where we are, then I think where the ombudsman stuff maybe comes in a bit is not that the ombudsman is a solution, or indeed strategic litigation is a solution, but it's perhaps like if we were trying to think of like how could this be done differently, drawing on the experiences that we currently have and things that we know work or don't work. Are there strengths in different parts of the system that if we were to sort of redesign it a bit, could make that process easier and better for people to use? So if you had a system which was accessible in the way an ombudsman might be, that may not be so heavily dependent on you having formal legal support and advice, that maybe has the impact of strategic litigation, that it could set precedents, and that there is some much more significant support mechanisms around that for people who are having to navigate that, so that, you know, whether you design something where it's like a one-stop shop, that you attend a particular office and from that somebody accompanies you through the process, signposting you and linking you up with the relevant people that you need to get through each stage, but it's taking the burden off one individual. You know, I think Emma spoke really brilliantly about the impact of, you know, people trying to navigate a complex system and trying to work it all out when there are lots of people in that system who it's their job to be doing this and they're not doing it. And so, you know, I mean, I'm currently studying in Barcelona. There's a human rights office in the city where you attend that office and you are assigned effectively like a caseworker, and it's a free service, and that person takes you through the process of raising a complaint. Now, it doesn't make making a complaint any less difficult or any less challenging, in the sense that that's a very tough thing to do about your rights, but that person is alongside you, explaining what's going to happen, connecting you with a mediator, connecting you with a legal team, connecting you with counselling service, whatever that service may need to be in that moment. And so I think sort of creatively thinking about some of these things, looking at what other places are doing, looking at what we currently have that could be adapted or could be incorporated into something else. Like, I think that's where we hope that these discussions might lead to, is starting to set out maybe another way of thinking about these things.
Thank you, Kate. I am going to move us on to the final question because we have 4 minutes left, but you can combine your answer for 3 and 4. So if you have something you wanted to say for 3 and you want to slide it in for 4, feel free. We've talked a little bit about good, but how do we get to good? What are the steps that we need and who needs to take them? What are things that need to be in place as a foundation to build on? And really importantly, what particular groups or communities do we need to think about to make sure the barriers are removed? Anyone want to jump in?
So I'll come in because I think there are some again, themes that are coming through. So this idea of monitoring and being proactive. So, you know, the National Audit Office in its report on the government's management of legal aid has already said that the MOJ just isn't collecting enough data about the situation on the ground. And, you know, the Law Society has been, you know, putting a lot of that grunt work in and, you know, trying to figure out where the gaps are. But until the organizations that are responsible for, you know, the delivery of this service are actually on top of, you know, the deficits, like it's just, we're not going to see. And it goes back to that idea that the legal aid crisis really is a crisis of political will, right? So it's a deliberate decision not to track and keep on top of these things. And then because, you know, we've been rightfully so dumping on the ombudsman, I thought we'd also just dump on litigation as well for a bit. And, you know, really thinking about this idea of, and, you know, I'm sure Emma will be able to speak to this more directly and, you know, in terms of what the communities that you're representing actually need. But there's this really interesting idea of clustered injustice and, you know, the problems with single issue lawyering, as I'm sure many of you will be familiar with. And this idea that, you know, individuals who face systemic disadvantage, they don't just have one legal problem, they need to bring one legal case to resolve. You know, that a lot of the time, you know, getting one decision quashed, it's not going to result in a net improvement of the situation because something else pops up to fill that gap, right? And it's, you know, like Kate, you were saying, it's this idea of joined up thinking, this holistic approach to, you know, not all problems firstly are justiciable or legal, even though, you know, our instinct as lawyers or people who work in this field might be to litigate or bring a complaint to the ombudsman. That's not always it's not always the root cause of what's going on. And it's really, yeah, just thinking about this constant mental cost of, you know, pursuing litigation, being on the back foot, being the one who has, being both on the back foot situationally, but then also having to be the one to step forward and bring that case. And even if you're working with, you know, as many of us do, organizations who, you know, whose hearts are in the right place and, you know, just want to help and be there, reaching out in itself, that there's a cost involved in that, working with someone else on their schedule to solve your issues. I mean, yeah, and many of you will be able to speak to, you know, the direct needs of the communities you represent better, but that's something I think is left out a lot of the, you know, traditional dialogues around things like legal aid. And I'm saying this as someone who's brought the traditional legal aid dialogue to this conversation. I just thought that was important to highlight.
Thank you so much for that, Saba. I'm going to jump in quickly to read this from Samantha. So if you had a more effective impact assessment requirement, which is beyond the have due regard, and that is enforceable if not completed properly, would be more effective in holding rights holder to account and ensure they were proactive. Excellent, Samantha. I'm going to Sara. I think you're probably going to get the last comment because we have a minute left and I don't like to hold people late.
Very briefly, just to say as a next step, if there's ever anything Tax Justice can help, you know, if you need a one-pager about, you know, where the money can come from or anything, I'll put my anything at all where we can help strengthen your case. Please don't be afraid. I know my presentation was a bit dense, but really we can make it really simple, but everything we say is really well grounded in research, etc. I'll pop my email in the chat. Please never hesitate to reach out if you can help at all.
Thank you so much for that, Sara. Do any of our panelists want to say a final word, or are we happy enough to wrap up? In that case, I want to say a massive thank you firstly to all our panelists. You were fantastic, but I also want to say an equally massive thank you to everybody who attended today. This has been such an incredible discussion and so helpful, exactly what we were hoping to get out of this and so much more. Don't forget, please do give us some feedback, because that's so important for us to figure out how to make these as valuable as possible. Sign up as well to our next one if you're interested, and do check out the resource page. Emma, Sara and Kate's presentations are already on there. We'll also do a written summary, and once I get the subtitles scripted up, I will get the video up, the recording as well. So thank you all so much, and I'll see some of you for the UK ESER now.